All right, what's good, everybody? So, I'm not going to waste any time. This is the Comprehensive Guide to Debt Discharge, UCC applications, and mortgage fraud prevention. This book will be coming out alongside this video for everybody who wants it. Now, if you're here, it's because you want to know about discharging debts. I don't really have much to say about that besides the fact that I have been doing this for about 2 years. I've been posting my entire journey along the way on TikTok and on Instagram. Now, I had an original TikTok page, Ignorance Be Gone, just Ignorance Be Gone, that was banned at 181,000 followers. Right now, this is my current TikTok, Ignorance Be Gone 2, with 70,000 followers. And I say that to show the receipts. As you can see, there's 200 posts. Some of these
See,
have
I told
multiple
y'all to take the
receipts.
class and you didn't listen.
Um,
But look at
this
this.
is
Just now I
everything
just
that
saw
we've
my
paid
credit
off,
report.
right?
Come on,
Helped pay
talk to
off,
me
discharge,
nice.
whatever.
I went.
So one of the examples you'll actually see contains IQ Data International for one of the 1099s because I actually used one of those to get those, as you can see, off of my own report. Next up, discharging a 15K bill, you know, just all kinds of
So I
receipts
just
on
want to start
here.
off by saying this video is for education.
Stamp method for a parking ticket,
It's
all
been a
types of
minute, so
things,
I'm back with good news. If
you
you
know,
listen,
different credit cards, different
who else
accounts,
is giving y'all remedy like past
evictions, all
to
types
everyone
of
who has signed up
different
for the
things.
Back to Basics Red?
So we have the receipts, we have the proof. Now let's just get right into the lesson. So, first thing that we're going to come across is obviously the table of contents in the chapter outline. Intro and understanding. Identifying and understanding financial contracts, understanding debt discharge, the role of the UCC in debt discharge, foundations of the UCC and financial terminology, practical methods for discharging debt, including, stamp method, 1099, A, B, C, all of that good stuff. Mortgage fraud, quiet title lawsuits, specifically mentions about cars, so we're going to get into all of that. Arbitration as a debt resolution strategy, and everything that goes along with that. How you can use that private mediation venue, legal protections and common pitfalls, as well as examples of how to fill out forms that you're going to need. And obviously, the disclaimer, the main disclaimer. I am not an attorney. I have not passed the bar. I am not a bar licensee. I do not have a bar card. None of this is legal advice. Please do your own research beyond what I present in this book. Take it to a deeper level. Always research everything that I say. The information contained here is gathered from my own personal experiences dealing with these companies and what I have learned through helping others these past few years. This is by no means an easy thing to do, and you must be willing to fight to enforce what you know, right? You have to be the belligerent claimant, but respectfully. So we have to know how to operate in honor. This is not a get rich quick scheme. This is not a get rich quick scheme. I cannot stress it enough. Please stay grounded in your actions. This may not work for everyone, and I am in no way guaranteeing success. I'm only here to provide educational materials. I accept no liability and will not be held liable for anyone who chooses to engage in any of the methods listed below of their own sound mind and free will. If you have any reservations about this process, don't attempt it. So now let's get into it, and I'm just going to go over a lot of this very briefly because we have covered this in depth. I've covered it on my page, and that information is available for those who want it, and I'll have other lessons diving into some of these other principles. But introduction and understanding. In today's world, we operate within a financial system that is largely misunderstood. The corporate structure of the United States, the transition from constitutional law to commercial law, and the role of contracts have created a system in which citizens unknowingly agree to financial obligations they may not even owe. And we're going to go through all of the history and prove all of what I'm saying. I have the receipts and the evidence on my page for people who want to look into those who have had successes. And this is just going to be information. This guide contains foundation as well as step by step. It's everything in one. This book aims to equip you with the financial knowledge and tools to navigate the system effectively. utilizing financial laws and UCC principles to reclaim control over your financial well-being. So, before we begin, there's certain facts that we must establish. This country, from its origin, has been a constitutional republic. Each of the 50 sovereign states came together to form a union which we call the United States of America. This country was founded on the principles of freedom for all within its borders, where every man is sovereign and free to govern themselves. Not to be confused with sovereign citizens, because you cannot be sovereign and a citizen. Such a thing is an oxymoron, as you'll hear a lot from people in this space. To be sovereign is to be like a king in your own right. No man has any authority over you except what you give. This includes the government, who get their authority from we the people. From the Colorado Constitution, the people of this state have the sole and exclusive right of governing themselves as a free, sovereign, and independent state, to alter and abolish their constitution and form of government whenever they may deem it necessary to their safety and happiness. So the people of this state have the sole and exclusive right of governing themselves. You will find this provision in almost all of the state constitutions. A free, sovereign, and independent state. Now, we as sovereign govern ourselves. And actually, let me go back just a little bit more. So, we have the sole right of governing ourselves as a free, sovereign, and independent state, and we can abolish our form of government wherever we deem it necessary to their safety and happiness, provided such change be not repugnant to the Constitution of the United States. This is similar in many other constitutions. We as sovereigns govern ourselves. The Constitution is the supreme law of the land, and judges of all states are bound to it. Anything to the contrary is nonwithstanding, basically meaning it's invalid and holds no authority. This comes from Article 6, Clause 2 of the Constitution, also known as the Supremacy Clause. Now, I would like to show you something that you might not have been aware of. Let's take a look at Article 1, Section 10 of the Constitution, which states that no state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin, tender in payment of debts. That is really the most important part of that, right? So there's two things to focus on. No state can emit a bill of credit, and no state can make anything but gold and silver tender in payment of debts. However, you might have noticed when we buy anything or tender payment for goods, we do not use gold or silver, but Federal Reserve notes or dollar bills. A Federal Reserve note is also a bill of credit, since there is no gold backing the currency. It is a debt note evidencing the government's promise to pay the gold's worth on the face value of the note. And you can't pay a debt with another debt. It says on the front of every dollar bill, this note is legal tender for all debts, public and private. Keyword being legal tender, as different from lawful currency, evidenced by 12 U.S.C. 411, which states that Federal Reserve notes should not be redeemed for lawful currency, or should be redeemed for lawful currency at the Treasury. However, they cannot give you lawful currency. So at this point, you're probably scratching your head a bit, because according to the Constitution, we shouldn't be doing any of this, but we are. Now, understanding the importance of debt discharge. Debt discharge is a fundamental concept that most people fail to recognize within the financial system. The global monetary system, particularly in the United States, is structured in a way that ensures perpetual debt. The general public has been conditioned to believe that debts must be repaid in full with Federal Reserve notes, but in reality, legal and financial frameworks provide alternative mechanisms for discharging debt. Since the United States went bankrupt in 1933, it has operated under an economic structure where all financial transactions are backed by securities and promissory notes rather than tangible gold or silver. This means that every financial contract, including mortgages, car loans, student loans, credit card agreements, is based on negotiable instruments. However, the average consumer is unaware that they have the power to challenge, negotiate, or even discharge a lot of these debts. So, one of the key reasons for understanding debt discharge is that it allows individuals to regain their financial autonomy. Most financial institutions utilize a system that involves securitizing consumer debt, and we're going to go over that very deeply later on. effectively converting debt into assets that are traded on financial markets. This process enables banks and lenders to profit multiple times from the same financial obligation while still demanding repayment from the consumer. By understanding how debt discharge works, individuals can legally challenge fraudulent debt claims and reclaim control over their lives, because you will find that most of these claims of debt are fraudulent. They can't prove it. The process of discharging debt does not mean evading responsibility, but rather asserting one's legal rights under commercial law. The financial system is built on agreements. When an individual properly navigates the framework of a debt discharge, they are simply utilizing the system's own rules to their advantage. Debt discharge is also crucial for breaking free from financial servitude. Many people work their entire lives to pay off debts that legally have already been settled through various means. The financial system functions on a cycle of extending credit, securitizing debt, and perpetuating a cycle of borrowing and repayment that ensures dependency. However, through the UCC and other legal provisions, it is possible to challenge these fraudulent claims and achieve true financial freedom. The legal foundation for debt discharge is deeply embedded in the U.S. financial and commercial law. A variety of statutes and legal precedents provide mechanisms for individuals to challenge and eliminate fraudulent or unlawful debts, with the first being the bankruptcy of the United States. So, one of the most crucial legal precedents for debt discharge is the bankruptcy of the United States. When the U.S. government declared bankruptcy, it abandoned the gold standard and replaced all forms of money with Federal Reserve notes. This meant that lawful money, gold and silver, was removed from circulation, and instead all financial transactions were conducted using debt instruments. House Joint Resolution 192 of 1933 made it illegal for citizens to demand gold for the payment of debts, effectively making all debts payable using legal tender and Federal Reserve notes. However, this also meant that all debts could be discharged through alternative financial instruments such as promissory notes and negotiable instruments, since that's what the whole system runs on anyway. So, in 1933, the constitutional republic died and was replaced by the corporate United States that is acting as the de facto government, existing only in title. This was the year we went off the gold standard. But as you already know, the fact of the matter is that the United States went bankrupt in 1933. It was declared by President Roosevelt through Executive Orders 6073, 6102, and 6111, and through Executive Order 6260 on March 9, 1933, under the Trading with the Enemy Act of October 6, 1917, as amended by the Emergency Banking Relief Act, 48 Statute 1, Public Law Number 1, which is presently codified at 12 U.S.C. 95A and confirmed by 95B. The Trading with the Enemy Act also declares all people within the country enemies of their state under the ADR Section 5, Subdivision B, Chapter 106. Enemy defined says any person within the United States, and you can confirm this for yourself by going and looking into those laws. Now, Congress confirmed the bankruptcy on June 5, 1933, and thereupon impaired the obligations and considerations of contracts through the joint resolution to suspend the gold standard and abrogate the gold clause on June 5, 1933. Of course, see House Joint Resolution 193 or 192. So, once again, it was passed by Congress on June 5, 1933. It impaired the obligations and considerations of contract and declared that the notes of the Federal Reserve Banks were legal tender for the payment of both public and private debts, and that payment in gold coin was against public policy due to the existing emergency of the Great Depression. More specifically, it stated, whereas the existing emergency has disclosed that the provisions of obligations which purport to give the obligee a right to require payment in gold or a particular kind of coin or currency of the United States, or in an amount of money of the United States measured thereby, obstruct the power of Congress to regulate the value of money and are inconsistent with the declared policy of Congress to maintain at all times the equal power of every dollar coined or issued by the United States in the markets and in the payment of debts. Now, therefore, it be resolved by the Senate and the House of Representatives of the United States of America that every provision contained in or made with respect to any obligation which purports to give the obligee a right to require payment in gold or a particular kind of coin or currency, or in any amount of money of the United States measured thereby, is declared to be against public policy. And no such provision shall be contained in or made with respect to any obligation hereinafter occurred. So every obligation that comes after this cannot be held to the gold standard. Every obligation heretofore or hereafter incurred, whether or not any such provision is contained therein or made with respect thereto, shall be discharged upon payment, and we'll go over what payment means, dollar for dollar, in any coin or currency which at the time of payment is legal tender for public and private debts. It goes on to specify that as used in the resolution, the term obligation means an obligation including every obligation of and to the United States, except in currency payable in money of the United States, and the term coin or currency means coin or currency of the United States, including Federal Reserve notes and circulating notes of Federal Reserve banks and national banking associations. So there can be no confusion, absolutely no confusion about what type of money they are referring to. So, the few main takeaways from all this is that in 1933, the government suspended the gold clause of the Constitution, which requires all debts be paid only in gold and silver, and replaced our currency with Federal Reserve notes, and declared that all obligations would be discharged dollar for dollar upon payment in any coin or currency which at the time is legal tender for payment of debts. So, in order to grasp the full weight of the situation, we must first look at the definitions of some key words used in the Act, beginning with defining with what an obligation is according to 18 United States Code 8. The term obligation or other security of the United States includes all bonds, certificates of indebtedness, national bank currency, Federal Reserve notes, Federal Reserve bank notes, coupons, United States notes, Treasury notes, gold certificates, silver certificates, fractional notes, certificates of deposit, bills, checks, or drafts for money drawn by or upon authorized officers of the United States, stamps, and other representatives of value of whatever denomination issued under any act of Congress. So all obligations, which include FRNs and other negotiable instruments, belong to the corporate United States. We must also understand what it is to be discharged according to Cornell law and other dictionaries. A discharge is the extinguishment or release of a legal obligation or duty. For example, a discharge of the payment of a debt means you are no longer legally obligated to pay the debt. So another way to read that is that every transaction which requires payment in gold, which would be every transaction, as the Constitution makes it very clear, has released us from any legal obligation to pay the debt. This is because we have no lawful money to pay. The government is responsible for the payment of all debts since they confiscated the gold and gave us bills of credit. So when companies say you owe them payment, it's fraud. And it has already been discharged, but more on that later. Now, I need to clear up something very specific here. When it states that the obligations belong to the United States, what the process of cashing in these securities is that they are presented to the Treasury for payment for an equal amount of Federal Reserve notes. So if it's a promissory note, for $5,000, then they bring that to the Treasury for the release of $5,000 minimum back, right? So whatever the face value of that note is, it's the collateral that secures at least that many notes. So it's not to say that the government has to pay all your bills, because if you look at the framework, the way the system is set up is that it's already that way. We have just been duped into acting how we've been acting. And again, we'll get more into that, but I just need to clarify what it means when people say, "Oh, the government is responsible for the debts," because yes, we have appointed them into that position to handle the money, declaring ourselves incompetent. So, now we have established the fact that the United States federal government has been dissolved by the Emergency Banking Act and declared by President Roosevelt being bankrupt and insolvent, right? So if we look at, I'm going to go a little bit further down here. Let me see. because that's just a lot more information. And I've already covered a lot of this, but it's very important that I go over at least some of this. So, this is the United States Congressional Record, March 17th, 1993. Speaker Representative James Traficant Jr. addressing the House. Mr. Speaker, we are here now in Chapter 11. Chapter 11 Bankruptcy. Members of Congress are official trustees presiding over the greatest reorganization of any bankrupt entity in world history, the U.S. government. We are setting forth, hopefully, a blueprint for our future. So, the bankruptcy of the United States has been confirmed in the congressional records. You can go pull this citation and find it and read it for yourself because it's there, I promise you. Now, let's keep on going here because, again, this is all important information. Yeah, here we go. Now, I understand that this is a lot to take in, and you may be wondering what that all has to do with your everyday life, as up to this point, you have most likely never heard of this information and have been going on about life. However, there are very far-reaching consequences to these actions that we cannot see every day, but will make a lot of sense once we apply it to real-life situations with actual court examples. According to the Congressional Record of March 9th, 1933, page 83, the value of our money comes from a mortgage on all homes and property of the nation. They leveraged everything in the country as collateral to back the credit of the nation. That is confirmed in that congressional record. Coupled with a $14.3 trillion lien on all people, which can be found via a UCC-1 search, and property in the country in the United States, the corporation has effectively made all those who identify as citizens into debt slaves. This means you don't own anything. I would look into the difference between a legal title and an equitable title. The title that you get for a state car is an equitable title giving you the rights to operate the state's property as that car belongs to the state as soon as it's registered. The true title for a car is the MCO, or Manufacturer Certificate of Origin, or Statement of Origin, MSO. The same for any home. The title is equitable. This is why they can seize those assets at any time. However, there is a remedy to all this, and remedy in law is means by which the violation of a right is prevented, redressed, or compensated. So when we're talking about remedy, we're talking about how to prevent problems, redress problems, and get you compensated for it. Now, the Uniform Commercial Code. The UCC is the primary legal framework governing commercial transactions in the United States. It provides the legal structure for negotiable instruments, contracts, and the enforcement of financial agreements. Some of the most relevant UCC articles for debt discharge include UCC 3104 negotiable instruments, defines what constitutes a negotiable instrument, which includes promissory notes and financial statements that can be used for debt discharge. UCC 3603, tender of payment and discharge, states that once a debt has been properly tendered for payment using an acceptable financial instrument, it is considered discharged. UCC 1308, reservation of rights, allows individuals to assert their rights when entering into contracts, ensuring they are not unknowingly wavering their ability to challenge unfair financial obligations. So when people are talking about writing this on their reservation of rights, it's so that you cannot be conned, and it just provides you a little bit of protection against that. Now, by leveraging provisions in the UCC, individuals can lawfully challenge debt claims and request validation of debts through proper legal procedures. Many financial institutions rely on the ignorance of consumers, leading them to believe they have no choice but to pay debts in full. However, by using UCC provisions, one can demand proof of claim, challenge the fraudulent lending practices, and enforce lawful discharge of financial obligations. 1099-C, cancellation of debt. We talk about that. It is a form that acknowledges the cancellation of a financial obligation. Lenders and financial institutions frequently use this form when they write off debts, but consumers can also utilize it to enforce debt discharge. When a debt is legally canceled, it must be reported to the IRS, and we'll find that they're not doing a lot of that. And the lender can no longer attempt to collect on it. By properly filing a 1099-C and ensuring compliance with IRS regulations, individuals can legally remove illegitimate debt claims from their financial records, including your credit report and things like that. Truth in Lending Act and the Fair Debt Collection Practices Act. Obviously, these are important. Truth in Lending requires lenders to fully disclose all terms of a loan, including interest rates, payment schedules, hidden fees. Many financial agreements violate TILA regulations, making them legally unenforceable. So we're going to be going into that because we need to understand how all of this works in a practical manner, how you can actually use this. And I'm going to be trying to give some focused examples of that when we get more into the actual things about discharge, right? Now, the Fair Debt Collection Practices Act protects consumers from unfair debt collection practices, including harassment, misrepresentation, and fraudulent claims. By asserting their rights under the FDCPA, individuals can challenge and remove illegitimate debts from their records. Debt discharge is not a loophole or an unlawful practice. It is a legally recognized process rooted in historical and financial law. Understanding debt discharge is essential for anyone seeking financial freedom, as it allows individuals to navigate the financial system with confidence and assert their rights against predatory lending practices. The legal framework supporting debt discharge is extensive, encompassing bankruptcy laws, the UCC laws, Treasury direct accounts, not too much, just a little bit, IRS tax provision, and consumer protection laws. By educating oneself on these legal principles and applying them effectively, individuals can eliminate fraudulent debts, regain financial autonomy, and break free from the cycle of perpetual debt. Financial sovereignty is attainable, but it requires knowledge, diligence, and the willingness to challenge conventional beliefs about money and debt. The journey towards financial empowerment starts with understanding these concepts and taking proactive steps to enforce your legal rights. The subsequent chapters will explore practical strategies for implementing debt discharge methods and utilizing legal protections to achieve true financial independence. To finish off, I have a few other books I recommend reading to help you out. Meet Your Straw Man and Whatever You Want to Know by David Robinson. Get it, read it, you need it. Common Law Handbook for Jurors, Sheriffs, Bailiffs, and Justices by David Robinson. Again, get that. The UCC Connection, How to Free Yourself from Legal Tyranny by David Robinson. I recommend that. Chief Justice Roberts on Obamacare and the IRS by David Robinson. Cracking the Code, The Fascinating Truth About Taxation in America. It is a great tax resource book. He has an entire website, losthorizons.com, where they show people's examples of how they file their taxes properly, how they got their refunds, how they got rid of certain obligations. You know, there is the Wise Trustee Handbook, and there's plenty of others that I don't have listed here. Fruit from a Poisonous Tree, you know, The Creature from Jekyll Island. All of these books I know contain a lot of good information, and that's going to be something very important that everybody reads. And for some resources, other things that you can read: Securities Exchange Act of 1934, Securities Act of 1933, the Federal Reserve Act, need to read that. Emergency Banking Act, need to read that. Trust Indenture Act of 1939. Bill of Exchange Act, which is UCC Article 3, Title 15, Chapter 41, which I want to say is it's consumer protection something. It might be TILA. No, I think that's just 1600. I forget what that is exactly, but I know it's important, which is why I put it there. Now, what is a financial contract? Moving on to Chapter 2, Understanding Financial Contracts. Now, Every financial obligation, whether a loan, mortgage, car payment, or credit card agreement, is governed by a contract. These contracts, when properly understood, reveal that much of what we assume we owe has already been satisfied through various financial mechanisms that are hidden from the average consumer. Key components of contracts, things that you need to understand. Offer and acceptance. This is important because more recently, in like the past few months specifically, I have been seeing a lot of letters come back where people will send off like a stamp or a remittance or whatever, and they will say, not, oh, we don't accept that type of payment. No, they'll say, to the extent that your offer, or to the extent that your instrument is an offer, we reject your offer, and we refuse the tender. So they're outright just saying they're refusing the tender at this point. They're not even trying to come with the nonsense of we don't accept it. No. And they're also telling people that it's non-negotiable. That's the other thing that I've been seeing recently as well, is that they'll say, oh, your payment is non-negotiable, but not only is it non-negotiable, we also reject your offer to the extent that your tender represents an offer. So these things are very important. And if you don't understand what offer and acceptance is, then you might think, okay, well, I don't really have a recourse to respond to this. But no, when they're straight up telling you, we are just, one, refusing your offer, and two, it's non-negotiable, what you need to be trying to figure out is, how can I make it negotiable? Okay, why is it non-negotiable? And what can I do? How can we engage in a manner that is going to be beneficial to both of us so that you will accept this offer of tender, right? These are all things we have to keep in mind. You can't be surface level. You have to really understand these concepts if you want it to make any kind of sense. Now, consideration, exchange of value. The way that it's supposed to work when you go get a loan, or the way that they tell you that it works, is that the bank has its pre-existing assets. So let's say the bank starts off with $1 million, okay, and they give you a loan for $100,000. The way that we're led to believe that this works is that they debit that 100,000 from the million that's already in their reserves, which we know that they don't even have that because of fractional reserve banking, but that they transfer that money from their account to your account. That is the understanding of how loans works, right? You had something of value that you gave to me, and so I must pay it back. But unfortunately, that isn't how it works. What happens instead is that when you go to get that loan for $100,000, you give them a promissory note. This is your consideration, your promise to pay. They then cash this promissory note in at the Treasury. So they receive the money based on the promissory note. They are supposed to be intermediaries between you and the Treasury. They get paid off of the interest and other things like that. But that money belongs to you because you are the one who created it with your signature. So they create the credit on their own books. So they just create that extra 100,000 and then subtract it from themselves and give it to you, so that it looks like you have to pay them back when that money should have come to you in the first place. Terms and conditions, obviously, and then security interests and liens, right? Because this is about contract law. And part of contract law is security interests, right? Part of why we can discharge cars is because they are not following the law when it comes to security interest and perfecting their security interest, having a proper lien, things like that. So we have to understand contracts and things like that, which is what's covered in this chapter. Types of financial contracts, loan agreements, right? Personal loans, auto loans, student loans, mortgage contracts, credit card agreements, lease agreements, securities contracts. All right. Now, there is some key clauses and implications for contracts that you need to understand. Fixed rate, interest rate clause, variable rate, and usury clauses. What's really important is the default clause, missed payments, right? A lot of people get their accounts closed because for some reason they stop paying their bills. I need to make sure that I scream this from the mountaintops. Do not stop paying your bills. Because if you have a default clause and missed payments is under that, then and they're not recognizing what you're sending them, then they have every right to go and close your account. You don't want to put yourself into a bad position. You never want to put yourself into a bad position. So never stop paying your bills until you are sure you have a remedy, because you never want to get yourself into a bad position. Or an acceleration clause. This allows lenders to demand full repayment immediately upon default. So if they can declare you in default, then they can accelerate that and say, no, we need all of the money now. No more terms of payment, things like that. So this is why it's always important to stay in honor. Staying in honor means doing things with clean hands and good faith. You are genuinely coming at this knowing that this is a negotiable instrument that you are trying to deposit and other things like that. But to be honest, the SNAP method isn't even my preferred method of going about debt discharge, right? It's actually my least favorite method, which is why we're going to go over all of the other ones and things that are necessary. But understanding contracts and contract law is going to be super important, right? Arbitration and dispute resolution clauses. Many contracts have mandatory arbitration clauses, waiving the right to litigation in court. This benefits lenders by limiting liability in class action lawsuits, ensuring disputes are resolved privately through arbitrators. Borrowers should consider negotiating contracts without forced arbitration to retain legal options. Now, assignment and securitization clauses. These clauses allow lenders to transfer or sell debt obligations to third parties. This is why you must revoke their ability to transfer. Don't give it to them. This includes mortgage-backed securities, credit card debt securitization, and auto loan-backed securities. A borrower's contract terms may change when a loan is assigned to a new entity, sometimes making it difficult to track ownership. Now, power of attorney, there's a lot of other things that go on in there. Now, understanding debt discharge. Most people don't realize that all debts are prepaid. This understanding stems from the historical legislative action such as the 1933 bankruptcy of the United States. The federal government assumed responsibility for all debts, but corporations continued to enforce payments through misinformation and legal loopholes. As we covered, they went bankrupt in 1933. The United States seized all the gold, and we were given in return unlimited credit and private securities. Now, since the federal common law was abolished in 1938 due to the Erie-Tompkins Railroad decision, all of our contracts fall under the commercial jurisdiction due to the delegation of powers doctrine. With that understanding, we first had to learn the rules of commerce to be able to operate in honor and properly manage our own affairs. The most important thing to realize is your place in the transaction. Once you understand your place, you better understand your responsibilities. In every company you do business with, you are the investor. If you want more evidence, look no further than the SEC filings for any particular company. This is from the third amended and restated indenture for American Express Issuance Trust II as the issuer and the Bank of New York Mellon as indenture trustee. And as securities intermediary, it states that eligible investments mean negotiable instruments, investment property, or deposit accounts which evidence direct obligations or obligations fully guaranteed as to timely payment by the United States of America. So your account is an eligible investment. Deposit accounts, negotiable instruments, your initial application. You are an investor. Or this section from the amended and restated indenture of Discover Card Execution Note Trust as issuer and U.S. National Bank as indenture trustee. So this is from American Express and now Discover. Permitted investments means negotiable instruments or securities represented by instruments in bearer or registered form, which evidence obligations issued or fully guaranteed as to timely payment by the United States of America or any instrumentality or agency thereof when obligations are backed by the full faith and credit of the United States of America. So we've talked a lot about full faith and credit and what that means, and that is again 18 United States Code 8. All obligations, Federal Reserve notes, debts belong to the United States, which is why these are investment accounts. So you will find similar clauses in most company filings. The reason these examples were chosen was to demonstrate that even if you are not aware, you have invested into these companies by way of your application, which is a negotiable instrument because they can transfer it to third parties. It says it in all of the contracts. Call them and ask them. They'll tell you that your application can be transferred to third parties. And also, you have deposit accounts with all of these institutions, which in most cases also qualifies as an investment into any particular company. The reason your application can be considered a promissory note is because it is a signed document that is transferable to third parties and also promises a sum of payment. Now that the facts have been established, let's take a closer look at your monthly statements from a company, right? It comes, oh, well, that image is slightly cut off, but you got the top part, and then down here, you got the perforated edge with the bond. I'm not sure why that opted to do like that. Now, more often than not, you will have a payment coupon attached, like in the example above. We have been misled about what the coupon is and how we should go about using it. We know that these companies use the commercial bank entry system, but what most people are not aware of is the fact that your statement is evidence of a security and registered in your name. Even though it is a predecessor note, as defined in the indenture agreements, you will find that it evidences the same debt. These companies have been sending us our money every month and having us return it to them freely as a gift, which they can redeem. The statement is also a bond with a payment coupon attached, and the regulations are well established. More specifically, it is a registered bond. Now, that is just some more information about that. Discharge mechanisms, 1099-C, 1099-A, the stamp method, and then taxes and the IRS. Because those are going to be, really, these are going to be the main ways that you go about discharging any one of your bills. And we'll talk about what each of those are needing to be. Now, we are moving on. We just got into Chapter 3. With the start of this here, understanding debt discharge, understanding that you're an investor, all of that information is provided there. Now, understanding the UCC in debt discharge. So, negotiable instruments defines negotiable instruments, including promissory notes, which can be leveraged to satisfy financial obligation. Defenses and claims in recoupments allows an individual to challenge a debt when fraud, misrepresentation, or improper procedures have occurred. This is going to be very important because there is a lot of fraud, misrepresentation, and improper procedures that go on that we can prove. This is why we're able to get our remedy, correct the wrong that was done against us. Now, UCC 3603, tender of payment and discharge, clarifies that once an individual tenders in an acceptable form of payment, the obligation is considered discharge, preventing creditors from further collection efforts, right? And then we already talked about UCC 1-308, but it is also important to look at here again. Now, we have some different scenarios in which you can do it. Lender initiated debt cancellation via the 1099-C, or the borrower, if they do not feel as though the company is reporting and they can also demonstrate insolvency or other legal grounds, they can avoid the tax obligation. Now, challenging fraudulent lending practices. When it comes to debt discharge, this is really the heart and soul of it. Consideration, right? I like to have tangible things that I can prove. That's why mortgages to me are the easiest thing. because chain of title fraud is established in the courts. It is a well-recognized doctrine. They can't prove they own the house. I like that. With cars, there's all sorts of dealer fraud and things that go on, and the fact that they never perfect the security interest. So when we are going about discharging it, we are challenging the fraudulent lending practices, which is why it's best if you have something that can prove it. That's why I'm a big fan of the securitization audits, because I don't like to argue. I don't like to go back and forth. I like to get the account audited. I like to get a QSIP number, because when I have the QSIP number, that opens up other avenues with, like 1099Bs and things like that. So I want my QSIP number. I want to show that they have transferred the obligation to someone else. They have transferred the obligation to someone else. They have given up their rights, title, and interest. That is what is discussed. Now, many debts originate from questionable financial practices, including lack of consideration when the lender creates funds through the borrower's promissory note rather than loaning existing money, failure to disclose material terms, transparency regarding interest rates, penalties, or contract terms, and securitization and sale of debt. When a lender sells a mortgage or a loan contract to investors, raising questions about the original contract's validity. By invoking UCC defenses such as UCC 3-305, individuals can argue that such practices void the legitimacy of their debt obligations, potentially leading to full discharge. So, you have the stamp, endorse, send method where you can endorse your financial instruments, send that over. Bankruptcy is really kind of like a last resort if you're in a really bad and tight situation. That will really stop most of what's going on. Repossessions, foreclosures, anything like that. But that's kind of like a last ditch thing. Now, arbitration as a debt resolution tool, because if you have mandatory arbitration, you're not going to be able to go to court initially. You have to go to arbitration, and they are bound by contract law, so there is a lot of things that can go right for you there, but sometimes they get paid off. A lot of stuff like that. Now, understanding the role of the UCC in debt discharge, because it plays a large role in what we're trying to do in terms of enforcing the law. Now, we have the obvious, the main codes that I've been listing throughout the book: 3104, 3305, 3603, right? When you properly tender a payment, the obligation is considered discharge. If a creditor refuses a lawful payment method, they forfeit their right to demand repayment, right? So, when we are dealing with challenges in creditor rebuttals, despite the protections offered by the UCC, creditors often employ tactics to dispute or undermine debt discharge claims. Understanding these challenges can help individuals counteract unlawful practices. Many creditors reject alternative payment methods such as promissory notes, arguing that only cash or electronic transfers are acceptable. However, under UCC 3104, it is legal tender, and if refused under UCC 3604, a properly executed negotiable instrument satisfies a debt obligation. The lack of standing to collect a debt. Creditors must prove that they have legal standing to collect a debt. If a loan has been securitized or sold to another entity, the original lender may lack the authority to demand repayment. This is very important and is covered more in Chapter 6. Misrepresentation of debt obligations. Some creditors attempt to enforce debts that have already been discharged or settled. Debtors can challenge such claims by requesting verification under UCC 9-210. Threats of credit reporting and legal action. Creditors often threaten negative credit reporting or lawsuits to coerce payment. You can dispute these inaccurate credit reports and assert their rights under the Fair Debt Collection Practices Act and the Fair Credit Reporting Act. This is going into the billing errors, and I'm going to go over how to properly use that because there's a lot of confusion about it. But if you successfully do your billing error, then your ability to dispute the inaccuracy of credit reports and assert your rights underneath the FDCPA and the Fair Credit Reporting Act go up even higher, and even under the Consumer Credit Billing Act, which is where that comes from. So, financial, terms and important things. Moving on to Chapter 5. We have to understand what negotiable instruments are: secured debt versus unsecured debt, holder and due course, consideration, again, default and acceleration clauses, and other relevant UCC information. Now, this just goes over the history of the UCC, but what I really want to go over in this section is the definition of payment. So, we have many good definitions in here, but the most important is going to be payment in regards to this. Let me negotiation. There's a lot of good information there. I know that I have it in here. Presentment, dishonor. Here we go. Payment. So, subject to subsection B, an instrument is paid to the extent payment is made by or on behalf of a party obliged to pay the instrument, and to a person entitled to enforce the instrument to the extent of the payment. The obligation of the party obliged to pay the instrument is discharged, even though the payment is made with knowledge of a claim to the instrument under Section 3603. This defines what payment is under the law. Payment is the delivery of a note by sending in your instrument. You have effectively paid whatever obligation is owed. This is why things are considered done once in the mail. And I cover that a bit more in the definitions about notice and how notice is given when you send something to the place where they normally do business. Now, obviously, tender of payment. If tender of payment of an obligation to pay an instrument is made to a person entitled to enforce the instrument, the effect of tender is governed by the principles of law applicable to tender of payment under a simple contract, which in this case is the UCC. Now, discharge by cancellation or renunciation. A person entitled to enforce an instrument with or without consideration may discharge the obligation of a party to pay the instrument by an intentional voluntary act, such as surrender of the instrument to the party, destruction, mutilation, or cancellation of the instrument. I'm going to just come down here and read what I had to say about that. Any of the acts listed above constitute discharge. If they destroy your instrument, send it back, refuse to send it back, try to erase the endorsement, any other action, it discharges the obligation. So make sure that you cite that when you're enforcing your instruments, because that's ironclad. That's no different than if I go to a gas station and I try to pay with cash and they say we don't take it, I'm out of there. Right? Article 8. But really, at this point, what we're going to get into is the meat and potatoes, why everybody's here, right? UCC 9.210, request for accounting. This is also important for gathering evidence. If they don't adhere to this request for accounting within so many days, you can secure default judgment. They must respond within 14 days after they receive the request. They have a duty to respond under the law, and you have a right to request the accounting. This is a part of establishing your burden of proof. Now, Part 3 is very important. It deals with the perfection and priority of liens. This section is where bona fide purchaser defense comes into play. It is due to the priority of security interests and liens, and since you were defrauded, that automatically gives you the highest rights and priority. I would read this entire subpart here, Article 9 of the UCC, just because. Now, we go over the enforcement section. I cover how to enforce your instrument. You're presenting negotiable instruments for payment. If they are dishonored, they have discharged the debt, and now the burden of proof falls on them. We now know that our instruments fall 100% within the definition of a negotiable instrument governed by Article 3 of the UCC because there is no conspicuous statement that it is not. Therefore, no company can tell you that they do not accept that form of payment as it is legal tender. Here are a few cases where courts have ruled that negotiable instruments and bills of exchange are legal tender. The Floyd acceptances, Wheeler versus National Bank, Bank of Pittsburgh versus O'Neill. I would just go search those citations. They are all verified. After you send off your initial endorsement and they do anything besides crediting your account, they have dishonored your payment, and you begin the steps of trying to solve this with them before taking other actions, right? Whether that be in equity court. Most of these companies are headquartered in Delaware, so you're going to have to take actions there anyways. Now, we talk about the notice of dishonor, the notice of default, right? Because they have obligations to you, and if they're not fulfilling them, you need to hold them accountable. If they don't answer your request for accounting, your request for validation of the debt within so many days, that is something where that's a clear violation of federal law. You got to hold them accountable to these standards. So it's important to understand the UCC and all of the enforcement things, and I'll talk a bit more about that when I'm going over each process in itself. Now, understanding securitization and its legal impact. Securitization is the process by which financial institutions bundle debt instruments such as mortgages and loans into securities that can be sold to investors. This process has significant legal implications for debt enforcement and repayment. How securitization works. A lender issues a loan to a borrower. The lender pools similar loans into a portfolio. These loans are sold into an investment trust or a special purpose vehicle. The special purpose vehicle issues securities backed by the income generated from the loan payments. Investors purchase these securities, receiving periodic payments from the underlying loan. So when we go and look at the transaction structure, you're going to understand why and how it always comes back to them, right? Because the money that they are funneling from you is going to paying off the investors who bought into this special purpose vehicle. Now, the legal implications of securitization. Lack of standing. If a lender has sold the debt, it may lack standing to collect on it. This is very important because all of these companies transfer all rights, titles, and interest outside of themselves, so they have lack of standing. Break in chain of title. The transfer of loan ownership must be properly recorded. If gaps exist in this process, then the legitimacy of debt collection efforts can be challenged. Every mortgage has this going on with the chain of title. Almost every single one. And the way that you can easily prove that is how many different servicers of your loan have you had and how many times has your deed been updated. If those numbers don't match, you may have a claim for a break of chain of title. Now, when challenging securitized debt, you have to demand proof of ownership under UCC 9-210. This forces creditors to demonstrate their rights to collect, verifying proper assignment. If the creditor lacks proper chain of title, they may argue that collection efforts are invalid, right? And invoking the Fair Debt Collection Practices Act and all other federal laws. This is how we challenge these unlawful lending practices, which is really what we're getting into. Now, a strong understanding of financial terminology and securitization is critical for asserting legal rights under the UCC. Recognizing how financial instruments are structured and transferred can empower individuals to challenge improper debt collection, negotiate settlements, and protect their financial sovereignty. The next chapter will explore practical methods for enforcing these rights in real-world scenarios. So give me just a moment. I'm going to go get a drink of water, and I'll be right back. All right, y'all. Let's not waste any time and get right into the practical methods for discharging debt. However, right before we do that, I just want to go back up to this section here talking about negotiable instruments underneath the UCC, just because. Now, a negotiable instrument means an unconditional promise or order to pay a fixed amount of money with or without interest if it is payable to bearer or to order at the time it is issued or first comes into possession of a holder, is payable on demand or at a definite time, does not state in the undertaking. But D is really the most important thing to look at here. A promise or order, other than a check, is not an instrument if at the time it is issued or first comes into possession of a holder, it contains a conspicuous statement, however expressed, to the effect that this promise or order is not negotiable or is not an instrument governed by this article. You will not find that on any of your statements. This is one of the most important codes because it proves that your monthly statements are negotiable instruments, especially once endorsed. If you look at subsection D, it tells you that in order for it to not be considered a negotiable instrument, there must be a conspicuous statement that the instrument is not a negotiable instrument governed by this article. All right, now back to Chapter 6. Step-by-step discharge process. We're going to go over the stamp method, endorsing your instruments, so whether that be car contracts, mortgages, and monthly statements, utilizing the 1099s, addressing a little bit about reclaiming your securities, and dealing with debt collection attempts. Now, this chapter is going to go into detailed instructions on how to do all of these things step by step. The stamp endorse send method is a process that enables individuals to properly discharge debts using legal financial instruments. It is based on the understanding that monthly statements and bills are negotiable instruments that can be properly endorsed and returned for settlement. This is obviously underneath UCC 3104. 31 CFR provides the guidelines for restrictive endorsements, and UCC 3603 dealing with properly tendered payments and discharged debts. Now, 31 CFR 328.5 from Title 31 Money and Finance deals with this specific section dealing with restrictive endorsements of U.S. bearer securities. It covers the form of endorsement. 328.6 gives the dimensions of endorsement. 5 through 8, I would read all three of those. More importantly than that, let's just get right down into it. This is what your stamp should say. For presentation to the United States Treasury for redemption or in exchange for securities of a new issue in accordance with written instructions submitted by, and then a blank line that will be filled in by the banks, or you can fill it in yourself. Now, if you're doing the book entry version, which is just a slightly faster method, it would say for presentation to the United States Treasury for conversion to book entry securities. Now, when you make your stamp, you want to make sure it fits the proper dimensions, which is 4 inches in width, 1.5 inches in length. This goes over how to properly make the stamp, but that's what it looks like. Really, it needs to be imprinted in a method where it's ineradicatable. It doesn't have to be a stamp. It can be anything that makes a permanent mark. You can format the endorsement on a computer, but make sure it's around the proper dimensions. Now, when it comes to how to use it, you stamp the bill, you endorse the instrument, and then you send it to the proper address. That does not have to be the trustee. Any paying agent of the company is required to make sure it gets to who it gets to. We'll go a little bit more into that when you make someone your fiduciary and things like that. These are the different kinds of endorsements. I don't really need to cover that too much, but this is what the actual endorsement says. Pay to the order of and name a payee. If it's American Express, it's American Express. If it is Discover, it's Discover. Now, you can also put the Treasury, as I believe that's why they have been saying that some of these are non-negotiable, but that's something that we can discuss at another time. It's not the most important for this guide. When you are doing it, again, pay to the order of and sign by your name / agent for your all caps name by accommodation / principal, as you are the agent. So now let's take a look at an example. This is somebody who did theirs $37,000. The receipt is posted on my page. As you can see, here's their Treasury stamp. It's not in the top left, parallel to the left edge, but that is fine. It's not going to break the process. He has a, all right, he has a gold back stamp on here. This gold back stamp is really just there to seal the document. I know that a lot of people are getting very caught up in, oh well, I think I need like $10 of stamps. No, you never need that much, especially because the denominations are completely off with inflation and things like that. The most important part of putting a canceled postal stamp on there is that it, one, seals the document and puts it into private jurisdiction. So that's really the main reason for doing that. But as you can see, paid to the order of American Express by agent for all caps name by accommodation principal. Amount written out, full, writing it out in, word form down here. This is a check. This is what it's supposed to resemble. And American Express will specifically tell you they take negotiable instruments. This is another person who did it, another receipt, different bill for $938. I posted the receipt on my page as well. As you can see, they have their Treasury stamp up here in the top left, and then they have their endorsement written out by hand with the simple 10-cent stamp. You want to make sure the stamps that you're using are backed by gold, 1 cent, 5 cent, 10 cent, and I believe the dollar stamp. But those are really the only ones that I mess with, and you shouldn't need anything else but a combination of those for any bill that you're trying to do. So, it is parallel to the left edge in both examples, even though it's in different places. One of them is not on the left. But yeah, so you stamp it, you endorse it, and then of course you send it. I want to briefly discuss the trustee and indenture trustee and whether or not you send your instruments there. The company is able to process the instruments as well as the trustee. Ultimately, it's always going to follow the same path. If it's sent to the company, they also send it to the trustee anyway. When you look at the indenture agreement, you will find that any paying agent is able to take care of the notes, and they are responsible for making sure it gets to the right party. The paying agents include the trust itself. Now, when it comes down to the 1099A and 1099C methods, the 1099A is really what you're going to want to use for anything that you acquired in the last 3 years, more specifically if it's a non-revolving credit account. When it becomes a revolving credit account, it gets more complicated. You can still do it, but if you got a car within the last 3 years, if you got a house within the last 3 years, or if you're trying to do a credit card and you have your monthly limit, you take that, multiply it by 12, and it goes into the box. So you want to use that for anything in the past 3 years. Now, if it is accepted and a few months have gone by and you're not seeing any updates on your credit report, no changes, that is fine. There is another step that is often not talked about, but I'm going to let you guys know what it is. So, when you file your 1099 and they are accepted, the way that you make sure that you recoup those credits is that when you are filing your taxes at the end of the year, whether it be a 1040 or a 1041 because you're doing trust, you want to include the amounts of your 1099, whether it be A, B, or C, onto your 1040 and or 1041 in the appropriate boxes, so that when you are filing your taxes, they make sure to issue that money back to you as a credit. So if you file the 1099A and it doesn't immediately discharge it off, that is fine. You still have recourse through the IRS. So that's going to be the same for a 1099C, right? The 1099C is for debts that are over 3 years old, over $600, or government debts, such as student loans, SBA, things like that, that you would handle those with a 1099C. And I'm going to have examples of where you go and how you would fill those out in the example section. So, you have the stamp method, where you take the 31 CFR Treasury stamp, place it in the top left, write your endorsement, pay to the order of, write the full amounts out, and send it to the company with certified or registered mail so that you have a return receipt. The return receipt is really the crux of that process in proving that it was delivered. Because what's going to happen most times when you do a stamp endorse send, they will tell you they never received it, that they lost it, or that they don't take that kind of payment, or more recently, what they've been saying is that it's non-negotiable and they refuse the tender. You have to know how to respond to all three of these situations. If they tell you they didn't receive it, you have a tracking number that shows when it was delivered. Somebody had to come in and sign for it. So somebody touched that document. There is an established chain of title. Do not allow them to get away with telling you that they lost it. Because guess what? Underneath the UCC, if they lose your payment, that is discharge. It is their responsibility. I have sent a payment to you. Prove that I did not send you a payment. Any of the games that they want to say, oh, well, what is the routing numbers? What is this? What type of payment is it? No, we're not getting into any of that. If you didn't lose my document, you would be able to tell me what type of payment that I sent you. So don't get caught up in those games. If they tell you that they never got it and you clearly have a return receipt, that is default. They cannot prove that they didn't receive it. And at that point, you don't have to do nothing but say, hey, look, judge, I sent them a payment and they lost it. They lost this payment. That is not my responsibility. How do I know that they're not going to lose another one if I send it? Right? Am I to just keep sending payments that are going to keep getting lost? Absolutely not. Same thing, you know, if they tell you that they refuse the tender or anything like that. Again, if you're refusing it, then I hit you with the UCC 3604. You are now refusing it. Now you're in default. I'm going to give you an opportunity to fix this, but this is legal tender. You have the burden of proof of showing me that it isn't. You have the burden of proof of showing that you still have a standing to collect this debt. So if they tell you that they lost it or that they never received it, you know what to do, right? Okay, now you're in default. There's nothing else that needs to be said about that. Now, if you send a payment, right, they tell you they don't get it, that is the point where the billing error comes in, and I'll get to that in just a second here. But when you're doing a billing error, you're not doing it for any other reason than the fact that you sent a payment, you have a return receipt showing it was delivered, and the credit has not been put on your account. At that moment, they need to stop, cease collection activities, do that. From receipt of your letter, indicating a billing dispute. Hey, look, I sent you a payment, it was delivered. I'm not seeing a credit to my account. Can you investigate? Right? If they don't say anything back at all, right, they never send anything back at all, that's the same as refusal. So you know what to do if they don't send it back at all. You know what to do if they tell you that they lost it, they can't find it, whatever. When you do a billing error and say, hey, look, I sent a payment, here's the tracking number, do your investigation, don't report negatively to my credit at this time. If you sent that letter, your billing error dispute, let's say you sent it on the 15th of February and they received it on the 18th, right? They received it on the 18th. I'm just throwing out dates. If they received it on the 18th and then on the 21st, they updated your credit report, that's a violation of the billing error law. They're not allowed to do that. Just them doing that act alone is enough fraud for you to discharge the obligation. So you have to think smarter with these companies because they try to think smart with you. Don't let them play you. Don't let them play you. If they send you something, you send something back. You include language in your documents like if you do not respond within 30 days, then everything that I state in here you are accepting as true, right? Unilateral contract. Trap them with your words. The power of language. Don't get yourself caught up. And you're in an even better position if they accepted your instrument at one point, but then they reversed it. Because at that point, when you are requesting the accounting, it becomes even more difficult for them. Because now they have to show that they didn't go back in and take that money out of your account without your permission. So if they accept it and then they reverse it later on, you already have your proof of claim. The same way that once you get them to discharge it, that's how you proceed further into trying to take over that account once you have some leverage on them. It's no different. It operates in the same way. So you got the stamp method, which again, you got to be snazzy. You got to know what you're doing. You have to be prepared for their nonsensical responses. Look, if you lost it, if you're refusing it, it's discharged. They can't escape that fact. Don't let them. Back them into a corner. Communicate in writing. You don't want to do talking on the phone unless you're recording all your phone calls, and even then, that may not be admissible. So do everything in writing. Make them write these things down. Then we got the 1099-C. Now, the 1099-B is used to report proceeds from a broker, right? A debt instrument is sold, transferred, or exchanged. We know that we are giving them debt instruments, and that is why we're able to file this form. Now, the proceeds from such a transaction are used to offset outstanding liabilities. It can provide a record of financial transactions proving the settlement or reassignment of a debt obligation, which is why that 1099 barter is so important, because if they are not reporting these things to the IRS, we must report them on their behalf because we still have a duty to do so. This form is what allows you to claim 10 times the balance of any notes bartered based on the fractional reserve principles, which is explained partially in Modern Money Mechanics by the Federal Reserve Bank of Chicago. We invest $1, they can lend out 10 more based on our deposit. If you're not sure about the 10x or feel as though you wouldn't be able to explain that or articulate that to the IRS, that is fine. Now, all the 1099 methods require individuals to understand the tax implications, as discharged debts may be reported as taxable income unless exemptions apply, which we have a gift exemption every single year, and all of these are estate and gift taxes. Now, if you don't see a remedy after your filings are accepted, that is okay. Make sure to include your 1099 balances on your 1040 and or 1041 with all the other applicable forms for filing a 1040, including a 706 and a 709 at the end of the year. When you go read the instructions for the 1041, it tells you what forms need to be transmitted along with it. So again, make sure you include those balances on your 1040s. That's how you get your money back through taxes. I mean, for the 1099-A, B, and C, the way that you get your money back, or that you will get money back if they don't just outright discharge it, is through your tax credits. Now, the billing error information, I really want to correct this because I know that there is a lot of people who are confused about that. So, many debts can be discharged or disputed by identifying billing errors and invoking the consumer protection law, such as truth in lending and the Fair Credit Billing Act. So, overcharges, duplicate charges, obviously. What we're focusing on, failure to credit payments correctly, right? That's really the main thing. You notify the creditor in writing. Send a dispute letter within 60 days of receiving the statement. Request validation. They must provide proof of validity of the debt. File a complaint. If they fail to respond, file a complaint with the CFPB or take legal action. So, legal remedies for billing errors or an example billing error. Let me just go there. If I send a negotiable instrument for payment and I have a return receipt showing delivery, I would send a billing error letter outline that I have sent a payment, the mail says it was delivered, but there has been no credit to my account. Please pause any reporting and collection activities until a full investigation has taken place. I would also make sure they comply with all legal standards associated with this request. Now, sending that in is how you can ensure that you are doing this process correctly. Most times, if you send in a billing error just by saying, I did a payment, it's not showing up, that is how you get them to respond and come back at you with, oh, we can't find it, or we never got it, or we just don't take it, right? Doing a billing error is something that forces them by law to respond to your presentment. That is the whole purpose of using the billing error, is that it forces them to respond. Right? Because if you just send something and you don't ever do a billing error, there is no evidence of wrongdoing, right? This is what I'm saying. Gather evidence, prove, stack up your data against them so that you can get a default judgment. Now, when it comes to car-specific information, right? Because we've covered the stamp method, the 1099 A, B, and C's, and again, I'm going to show the examples of those relatively shortly here. Now, for cars specifically, you can do the stamp method, right? Whether you are stamping the car contract itself to do the entire thing at once, or the monthly statements. Same thing with a mortgage. If you're doing the mortgage promissory note or trying to do a monthly statement, they can be done for that. But as I stated, the stamp method is not my favorite method for discharging. And if you couldn't tell why, I mean, you hear me describing like the back and forth that you're going to have to go through in playing these games. Now, there's kind of ways that you can subvert that and, you know, get into that, but I'm going to get into that in just a second here. Now, when it comes to cars specifically, requesting a bonded title can force creditors to prove full security interest in your auto loan. And if they fail to do so, you get the title by default. They cannot prove the security interest. This is why if you do a lien search on yourself in your state, the debtor state where it's supposed to be, you won't find it. Applying for a bonded title is an easy way to secure your title. Just go look up the bonded title application in your state. Fill it out. That is going to force them to prove that they have full security interest. Challenging the lien. A bonded title is a form of challenging the lien. Liens must be filed in the debtor state. Most companies do not have liens filed in your state against you, evidencing full security interest. Get a certified copy of a lien search performed on yourself from your state and use that as evidence to challenge their security interest. Certified copy of the UCC system in your state and say, hey, look, there's no lien. And according to the law, it must be filed in this state, not another state. That's not perfected security interest. That can be challenged, brought before a judge, however you want to do it. If they're not taking just the certified copy and wanting to listen to you, sometimes you got to buck up. Now, bona fide purchaser. Most companies have pre-existing liens through the issuing entity and their depositor entity. If you do a certified UCC search through Delaware via a certified company, you can pull the UCC filed between those entities that pledges all car titles as collateral. You can use this to show that the title had previous equities and received the title due to that fraud as well. Now, at this exact moment, I don't have an example of one of those in here, but now that I'm thinking about it, I'm going to add it to the examples so that when this fully comes out, that will be an example in there. Notary fraud. Car contracts must be assigned to the banks that service the loans. The assignment must be notarized, and since you were signed on there, this must happen in your presence. 99% of the time, it does not. Not only that, but most finance managers act as notaries on the contracts that they are a party to, which is dealer fraud. This can also be reported and used as a claim of defense that the contract was not executed properly. So when it comes to cars, the big deal with cars is the lack of perfected security interest, which is why when you understand the laws regarding security interest, it makes it a lot easier to challenge that and get the title to your car. So you have the stamp method, you have your 1099As that you could do for a car that you got within the last 3 years, but then you may have to wait on the taxes for that to fully come back. Same thing with any of the other ones. The only exception to that is the 1099 barter, because that form in itself triggers an audit and an investigation into the company. And so most of the time, after a few months, you'll see something pop back with the 1099B. Now, other relevant discharge information. This is what y'all have to understand. Focus on gaining leverage. The easiest way to do this is through a securitization audit report. I recommend Mortgage Audit Online as they do credit cards, car loans, and mortgages, done by experienced auditors whose affidavits have been used in a variety of court cases. This is an easy way to demonstrate chain of title fraud, specifically for mortgages, or lack of standing to collect on a debt for auto loans, other things like that. Not to mention the fact that the debt was paid and they sold it and they already received payment multiple times. That can be proved by the audit. So there's a lot of beneficial information, as well as the fact that if you do an audit report on one of these accounts, when you're filing your 1099Bs, you'll actually have a QSIP number that you can put on there. Now, in place of a QSIP number, you could also just do your social security number, because as we have learned, even if you have a QSIP, that's attached to a pool of securities. So in order for them to specifically find what is yours, you can put your social there. Avoid using the words discharge or treasury direct account. Don't say that stuff. You don't want your account blacklisted or flagged as a sovereign citizen. If they peg you as somebody who doesn't want to pay their bills, or if they think you're dumb enough to be classified as a sovereign citizen, you're going to get very disrespected by the companies. They're going to be a lot less willing to work with you. So I don't like to mention discharge or, any of that stuff. I focus on the fraud. Like, hey, look, y'all sold all rights, title, and interest into this trust. You gave up beneficial ownership. I'm not understanding where my obligation is coming from at this point, right? So you just have to be smart about how you're going about this, right? This is why I say be realistic. Think about what you can prove. Baseless accusations will get you nowhere fast, and that is a promise. Enforce federal law. If you want to ensure compliance, hold them to the letter of the law. If you send a debt verification and they do not respond within 30 days, this is a blatant black and white violation of the law, and you're entitled to damages, right? If you go look at the debt verification law and then you go look at what damages you're entitled to if they violate it, you can get paid for this. So get paid. You have the evidence to show that they didn't respond. Like, it really doesn't get any easier than this. Like, if you can get them caught up in all of these different violations, kind of leading them into some of them, you shouldn't have any problems. Don't let them outfox you. Like I said, if they send you something, you send something back. Never let them have the last word. The one who loses is the one who walks away from the battlefield first. That is a maxim of law. That is. So, you're entitled to damages. You can even nullify the debt. Pay specific attention to any laws requiring disclosure within a time frame. If they don't respond or it does not meet the required elements, file a claim. You cannot lose. Stay in honor. Always make sure to do everything with clean hands and good faith. Continue to pay your bills until you see a remedy. If you stop, they have every right to close your accounts. Do not put yourself in that position. If you continue paying, they have no reason to close your account. And if they do, it's much easier to get it reopened. But again, you guys have to determine how much you want to fight with these people or not. And ultimately, I have decided I don't want to fight with these people. I just stick to what I can prove because that's what works for me. Now, if they had previously accepted your instrument, but they reversed it, make sure to request the full accounting to show that they did not deposit your instrument. The fact that they accepted it already gives you leverage. Now they're using sneaky accounting to try to trick you into paying more FRNs. The information for requesting that accounting is under the Federal Accounting Standards 125, Accounting for Transfers and Servicing of Financial Assets and Extinguishments of Liabilities. Which provides accounting and reporting standards for transfers and servicing of financial assets and extinguishments of liabilities. Those standards are based on consistent application of financial components approach that focuses on control. Under that approach, after a transfer of financial assets, an entity recognizes the financial and servicing assets it controls and liabilities it has incurred, and it de-recognizes financial assets when control has been surrendered, and it de-recognizes liabilities when extinguished. This statement provides consistent standards for distinguishing transfers of financial assets that are sales from transfers that are secured borrowings, or in layman's terms, securitized accounts. This is important because beneficial ownership is sold into a trust, so they don't control the asset anymore. They must de-recognize the financial asset when control has been surrendered. Also, use all other enforcement measures, including notice of default and opportunity to cure, before requesting a default judgment. What we're trying to do is what they do to you. When they come and repossess your car, how do they do it? They secure a default judgment. Hey, we sent them notices of payment, opportunities to cure. They still haven't paid us. Here's our evidence. Default judgment against them. You can do the same thing to them. Hey, I sent them debt validations, verifications. They didn't respond. I did a billing error dispute. They didn't respond. These are clear violations of federal law. I have been damaged. What is my remedy? It's open and shut. It's open and shut. That is how I like to deal with things, open and shut. Make sure to revoke all security interest, remove power of attorney via a letter. I revoke power of attorney from this company, and update the power of attorney with your information via 2848 that you file with the IRS. Send a copy to the company. I would recommend that you appoint a fiduciary agent at the company, either the CFO or trustee, via public notice in the newspaper till you get an affidavit of publication and with the Form 56. What I mean by that is that you want to have an enforceable claim against these people. What better way to do that than one, to revoke their security interest, appoint yourself as power of attorney, and appoint their CFO or their trustee as your fiduciary. Not only do you appoint them as your fiduciary with Form 56, notice goes to the IRS and the company, you also will have it in public notice, and you send your affidavit of publication and your Form 56. I would send that to whoever you appointed as your fiduciary so they know. And if they don't come back and fight it within 3 days, then it stands. So make sure that you perfect your security interest via a lien filed on the company with your account number as collateral filed in the debtor state of origin, which most of the time is going to be Delaware. So you're going to be filing a lien on American Express, on Discover, on whatever company you're dealing with. Most likely they're headquartered, registered in Delaware. Their jurisdiction exists wholly in Delaware. So that's where you're going to file your lien, which is going to evidence your security interest, which is why you have to go and look at Article 8 and Article 9 of the UCC so you understand secure transactions, perfecting security interest, and all of the required elements that go along with that. All of that information is provided in this book. Now, you also want to make sure to change the responsible party to yourself on Form 8822B since you're the representative. The reason that you want to do this is because if they are responsible party and they have power of attorney, they are in control of your account. But when you have your security interest expressed, you have your power of attorney over the account, you've appointed them as fiduciary, and then you switch yourself over to being the responsible party because you're not a minor, right? You gave them the authority to be your responsible party. Take it away. Some interesting things are going to start happening with your account is you're going to start receiving correspondences that normally would go to them on your behalf for things like treasury checks, all of your interest payments essentially. Now, for all accounts with transaction amounts over $10,000, make sure to fill out Form 8300 to notify the IRS. Since they removed the assets from the balance sheet, it is likely that they are not properly reporting to the IRS. So we must make sure that we do so because, again, when they securitize loans, they remove them from the balance sheet. I recommend everybody read the OCC Asset Securitization Manual because, I mean, it breaks down securitization. It talks about how even though securitization is something that they can do, they have to comply with the laws, more specifically regarding, chain of title and standing to collect on debts. So we know that they're not reporting to the IRS, which is why we report to the IRS for amounts over $10,000, because that's going to also trigger an audit of them. And again, they're not reporting these payments most likely. So the stamp method, 1099, and billing disputes provide powerful tools for individuals seeking debt discharge. By understanding the legal basis and following proper procedure, individuals can assert their rights under the UCC, IRS regulations, and consumer protection laws. Examples of all mentioned forms will be included in Chapter 10. Next, we're going to get into mortgage fraud and quiet title lawsuits. This is going to be probably the most complicated part of the video. The other methods, again, with the examples, it's easy enough to figure out how to do those. We've given the history behind it. But mortgages, on the other hand, I really want to get into it. And so a part of this is going to be how to use that audit if you get it, or just discussing how it will help you with a quiet title lawsuit. So let's get into mortgages, because mortgage really is its own entity that I like to consider separate from other things when discharging. Now, the fraudulent nature of mortgages is what we're going to go over, using quiet title lawsuits to challenge fraud, and then understanding mortgage securitization fraud. So, how banks securitize and sell mortgages without informing borrowers, the separation of the note and the deed, and how lenders create fraudulent claims to property ownership. Legal process of a quiet title action, gathering evidence to prove fraud, court procedures, and potential outcomes. I may or may not include an example of a quiet title action. Let me know in the comments if y'all want it. Um, Mortgage securitization fraud occurs when lenders and financial institutions unlawfully package, sell, and profit from mortgage-backed securities without proper disclosure to the borrowers. The complexity of securitization allows for fraudulent practices that disadvantage homeowners, often leading to unlawful foreclosures. How mortgage securitization works. A borrower signs a mortgage agreement with the lender. The lender sells the mortgage to a special purpose financial vehicle SPV, usually without the borrower's knowledge. The SPV bundles the mortgage with others into a mortgage-backed security, MBS. Investors purchase these securities, profiting from homeowners' mortgage payments. The original lender no longer holds the mortgage, yet often continues debt collection and foreclosure proceedings without legal standing, which they can't do. Identifying securitization fraud. The mortgage has been transferred multiple times without proper assignments. The lender cannot produce the original promissory note. The borrower was never notified that their mortgage had been sold. Foreclosure is pursued by an entity without legal ownership. And these are some important details and facts. I'm about to break down why it is that you can never lose a quiet title lawsuit against the mortgage company. So, the intangible debt obligation, represented by the promissory note, when securitized, is owned by whatever trust they sold it into. So the intangible debt obligation is owned by whatever trust they sold it into. So most of the time it'll be a Ginnie Mae or a Fannie Mae trust, right? However, it can only be determined if the original note had been physically delivered to the trust by checking with the custodian of documents. Until then, there's no evidence that the trust possessed in any manner the note before the rights to the intangible debt obligation were stripped away shortly after the signing of your deed. The beneficial interest ownership of the deed of trust has been recorded in the official records of your county recorder's office as being in the name of your mortgage company, the original lender of the loan, on the date it was signed. However, it is clear that most mortgage companies sell all ownership interest in the intangible debt obligation to Ginnie Mae or Fannie Mae shortly after the interest in the intangible debt obligation is held in the trust, and the payments made under the intangible debt obligation are dispersed to the investors of the trust, who hold certificates to the investment classes into which payments under the intangible obligation, the debt, are scheduled to flow. Therefore, the transfer of beneficial interest in the deed of trust by the mortgage company might be accomplished, but that beneficial interest is no longer attached to the rights of the intangible obligation, being the debt. Basically, what this means is that when they sell the interest into the trust and the money that you guys pay back into it goes and is dispersed back to the investors, but they cannot transfer all the rights that go along with that. So, Ginnie Mae and or Fannie Mae has most likely purchased an interest in your mortgage loan and delivered that interest in your mortgage loan. I keep saying your mortgage loan, but that was because this was from something else. A trust claims to have control of your note and your deed of trust, right? In order for that to be true, it would have to have both. But by the trust purchasing the intangible debt obligation and doing with it whatever was done, the trust is exercising rights of ownership over your mortgage loan and the payment stream. By exercising rights of ownership over your mortgage loan and the payment stream, the trust is making a claim of rights to all three parts of your mortgage loan, a claim which is misplaced. Your mortgage loan only exists through the tangible instruments creating it. the promissory note, the deed of trust, the sale of the rights to the intangible debt obligation to the trust without stripping away the rights to the intangible debt obligation from the rights to your note could only be accomplished with the accompanying negotiation of your note and the accompanying assignment of your deed of trust to the trust, which has not happened, whereas the trust as a standalone party has not lawfully been conveyed your note, much less been filed of record as a secured creditor. I know this is a little bit difficult to understand because it's a lot of legalese and mortgage speak, but basically what this means is that anytime they transfer the note, they must transfer the deed as well. And that assignment of the transfer of the deed must be recorded in your county recorder's office. Otherwise, when they separated the deed from the note and violated the chain of title, they separated the rights to the payment from the actual note itself, leaving the deed without anything to enforce. That is ultimately what it comes to, and it's going to be made more clear as I keep going through here. So, the trust has an interest in your intangible debt obligation. However, the transfer of rights of either the two tangible parts of the loan instrument that evidence your intangible debt obligation from the mortgage company to the trust is not memorialized in the official records of your county recorder's office in a manner which observes United States Code. Underneath the Consumer Credit Protection Act, Title 15, Chapter 41. Yeah, that was truth in lending. I knew it. I knew it earlier. Any transfers of your mortgage loan to the trust would be in violation of federal statute if those transfers had not been recorded in the official records of your county recorder's office within 30 days, along with notification of yourself and all applicable parties that the transfers had occurred. As there is no record of assignments of your deed of trust to whatever trust they sold it into within 30 days of your closing date, either there has been a violation of federal law, or the trust, who has interest in the intangible debt obligation, are not the owners of the note or the deed of trust. Now, under the Truth in Lending Act here, Consumer Credit Protection Act, notice of new creditor. In addition to other disclosures required by this subchapter, not later than 30 days after the date on which a mortgage loan is sold or otherwise transferred or assigned to a third party, the creditor that is the new owner or assignee of the debt shall notify the borrower in writing of such transfer, including the identity, address, date of the transfer, how to reach them, the location of the place where the transfer of interest is recorded, and other relevant information. There needs to be an assignment every time it's sold, and they never do. This is why they can't prove chain of title. Like I said, if you have a new servicer, where is the assignments that are recorded down in your county? They don't exist, and therefore the mortgage is a nullity. So, the trust is claiming to certify, if they're trying to initiate foreclosure, that an assignment of your deed of trust, I meant to say deed of trust there, has been accomplished by selling certificates of shares to the trust, to the investors based on the placement of your mortgage loan. However, there have been no assignments of your deed of trust to the recorded in the official records of your county recorder's office. Although both Jeannie Mae's own requirements and Colorado state law, which I'm just using because I'm in Colorado, most state laws as well, but I'm using specific examples from the Colorado property laws, require assignments memorializing the sale and negotiations of your note along with the acquiring of rights. Therefore, the trust appears to have violated Title 18 United States Code, Chapter 47, subsection 1021. A duly recorded assignment of your deed of trust constitutes a constructive notice, while an unrecorded assignment of your deed of trust is notice to only the immediate parties. With constructive notice, all persons attempting to acquire rights in your property are deemed to have notice of the recorded instrument. In this way, the recording statute is intended to expose the chain of title of your deed of trust to inspection by examination of real property records, protecting innocent junior purchasers and lenders from secret titles and the subsequent fraud attendant to such titles, which is kind of like the bona fide purchaser thing, right? It's the same type of thing. Assignments of your deed of trust must be accompanied by a parallel endorsement of your note for your mortgage loan to remain secured by your property. Because endorsements are very often undated, and because a plaintiff must prove that it had standing at the inception of a case, the assignment will be determinative of, or at least evidence that would support or contradict a plaintiff's claim of standing. No evidence is available to evidence negotiations of your note to the trust. This would have required endorsements and proper negotiations of your note from the mortgage company to the trust, including any intervening claims of ownership. Of course, for your mortgage loan to remain a secured loan, there would have been assignments and transfers of the beneficial interest of your deed of trust concurrent to the negotiations of your note. And those transfers of your deed of trust would have had to be entered into the official records of your county recorder's office. The trust, who has an interest in your intangible debt obligation, cannot show that accompanied negotiations of the right to your note have been done in there. And I gotta take out that name because this was from something that I was working on for somebody's mortgage, which is where I'm pulling this information from, and I just left their name there, so I'll have to edit that out. That's easy enough. The rights to your intangible debt obligation have been stripped away from the rights to your note and the rights to your deed of trust. An assignment recorded now would do nothing. And I really go into the fullness of, breaking down why it is that they cannot enforce anything like that. The mortgage contract is a nullity, but I've gone into enough of that. Now, the way that you remedy this whole situation is with a quiet title lawsuit. A quiet title action is a legal process that allows homeowners to challenge fraudulent claims on their property and establish rightful ownership. This is especially useful in cases where mortgage assignments were improperly handled or if lenders cannot prove their legal standing to collect payments. The grounds for filing a quiet title lawsuit. The entity attempting foreclosure cannot prove ownership of the mortgage. There are fraudulent or improper mortgage assignments. The original lender securitized the loan without disclosing the transfer. The borrower disputes the unlawful foreclosure proceedings. Research and documentation. That is going to be a part of your audit. If you get that, you can prove everything that you need. Submit a legal action in a state court or federal court requesting to clear the title. Prove lack of legal standing. Show that the lender or servicer does not legally own the mortgage. Request a judgment. If successful, the court removes wrongful claims, affirming the homeowner's title free of illegitimate encumbrances. OCC Asset Securitization Manual. The Office of the Comptroller of Currency, OCC Asset Securitization Manual, provides the guidelines on the legal processes of securitization. Understanding these guidelines helps borrowers challenge fraudulent mortgage practices. Securitization must be properly documented with valid assignments. Borrowers must be notified if their loan is securitized. Financial institutions must adhere to legal transfer processes and comply with mortgage ownership laws, which is what I'm showing all through here with the transfer of rights, showing how they can't receive rights because it wasn't transferred properly. All of that is done in there. Now, if a lender fails to meet these requirements, their claim on a mortgage may be legally voided, strengthening a homeowner's case in a quiet title lawsuit. A special purpose financial vehicle is an entity created to hold mortgage-backed securities, shielding financial institutions from liabilities. These structures complicate mortgage ownership, often leading to fraudulent foreclosures. The role of special purpose vehicles in mortgage securitization. They receive ownership of pooled mortgages but do not directly interact with the borrowers. They allow banks to offload risks while still profiting from mortgage payments. Many foreclosures are pursued by servicers rather than the actual owners of the mortgage, raising legal challenges for homeowners. So the way that you can challenge the special purpose vehicles claim is demand proof of ownership and original documents under UCC 9-1010 and the Federal Accounting Standard 125. Investigate the chain of title and assignments to see if it was unlawfully securitized, which you can do partially through an audit, which is why, again, I'm so big on it, because I'm big on proof, tangibility, staying grounded. Now, mortgage securitization, fraud, and improper foreclosures continue to impact homeowners. By understanding the quiet title process, OCC guidelines, and the role of special purpose vehicles, individuals can challenge fraudulent claims and reclaim their property rights. The next chapter will explore arbitration as a debt resolution strategy. Now, we're not really going to cover that because this video was really just talking about discharging debts and how to do that. If you're going into claims and things like that, like I said, this book will be coming out alongside the video for anybody who's interested in, whatever is missing here. So right now, there is Chapter 8 deals with arbitration, Chapter 9 legal protections and common pitfalls. But really, we're going to get to the examples here. So I have a cover letter 1 example for a mortgage detailing your intent to sue, right? Something you do before you file the quiet title lawsuit to give them notice of what you're doing, right? So to whom it may concern, this is based on the idea that you have a mortgage audit, right? To whom it may concern, the account referenced above has been audited for violations of the securities laws. I have evidence that the above stated mortgage that I have received from your company has been securitized, which is a scheme in which companies issue credit to consumers and then seek to collect amounts allegedly owed to them, but which are not legally due. In this case, the mortgage company, in accordance with trustee bank, have unlawfully purported to assign, transfer, or convey the interest in my promissory note on or before the closing date of the trust it was sold into. Mortgage company also never negotiated the tangible note by operation of law for full value in accordance with all applicable law to sponsor. The audit displays that there has been a clear separation between the note and deed, and these were never properly recorded. And it just talks in detail a little bit more about how this works with actual examples of like the guaranteed remit pass-through trusts that they do. And even the act that goes along with those rules. So I have the cover letter for a mortgage. I have another one for credit card, auto loan, monthly bill. I'm actually going to go and just do it like this very slowly so that people can pause and get what they need to. I would just pause when it's frozen so you can get an idea of what that's supposed to say. All right. I'm going to go back up again just to be safe, just so everybody knows. This is what it's supposed to look like. I'm going to go over these real slow. And again, these are all going to be included in the book as they are here. Number 2, again, that one's much shorter. But now we get into the actual form example. So 1099A instructions. The instructions are here. I'm not going to read through all of these. I'm going to let people just pause and read through it. Just because, you should be able to get everything that you need. All right, so here's the 1099A example. This is what it looks like. First name, dash, middle name, followed by last beneficiary, right? Lender's 10 is going to be you, obviously. You're the lender on the 1099A. Date of acquisition or abandonment is the day that the account was opened. If you are doing a monthly bill, like for example, if I'm doing a credit card that has a $5,000 credit limit every month, you multiply that by 12 for 12 months, and that's the fair market value. Account type goes in the description of the property. You want to check box number 5. You can either replace that account number with your account number or use the auto-generated number that they give you. But this is, again, really self-explanatory. The instructions are here. right? The instructions are here. So on to the 1099-C instructions. Same thing. Debtor's address, that's you. Creditor, that's the company. The debt information, all of this is what you're going to need for that. Scrolling on now. All right. So here is the 1099-C, where, as you can see, the company is now the creditor. You are now the debtor. Those roles have been reversed. The amount of debt discharged you include in box 2. The date of identifiable event is the day of the charge off. You could do today's date, debt description. And as you can see, IQ Data International, if you remember from the beginning of this video, I actually was showing the IQ Data International being removed off my credit report. That was partially done via 1099-C. As you can see, I had it filed. The blue means the boxes were pre-filled, but yeah, so that's how you do that. 1099-B. You need to fill this one out twice. One with the institution as payer, and one with the institution as recipient is what I meant to say there. I see I have a few edits to make before I fully drop this. Yeah, one with the institution as the payer and one with them as the recipient. The examples that I provided come from the Recoupers group, who you can find through the Remedy Room Telegram, on the TikTok of Ignorance Be Gone and Ignorance Be Gone 2. That's TikTok and Instagram. You can find me on those platforms. Now, before filling out 1099-B, you need to collect all the proper information, what goes in there. Like I said, I'll just leave that there for people to look at. I also may just do a Google Drive and put some of these examples in there to go along with the video. Again, let me know if y'all maybe want that in the comments. All right, here's the first one. As you can see, bank name, they are the payer, bank EIN, your SSN, first, middle, last, address, account number. You fill in these boxes here. Real money monetized by 10. Again, that comes from the fractional reserve banking principles. The date, first day of the year, last day of the year, deposits times 10, because that's what you're bartering. Next up, one with yourself as the payer and the bank as the recipient, because it goes both ways. So this is where you go. Same thing, real money times 10. Basically, fill it out the same way. Real simple. Should need to get more specific than that. Pause it, copy it down, whatever you got to do, screenshot it. 2848. All right, let's take a look at the 2848. Here it is. Here it is, right? All caps, name and address. Obviously, your SSN goes over here. You could do your trust, your all caps, or your upper and lowercase in its proper legal format. You need a CAF number, phone numbers, addresses. All of this is what goes on the 2848. Description of matter, all matters, all matters, all matters. Specific form numbers, if applicable. This is most forms that you're going to need. Yeah, I would just copy down what I have here in these examples. All right, Form 56. This one is another really kind of self-explanatory one. This is an example of one that Patrick Devine did, but obviously you just replace your information in the applicable spots. If it's not for court, you don't have anything on there. If it is for court, make sure you get the judge to sign that in chambers, but that's neither here nor there. If you really want to close out a court case, make sure that that fiduciary is assigned. This is how you do the Form 56 and or 56F. It's going to be the same type of format. It's really self-explanatory. Same thing with Form 8300. I mean, last name, first name, tax ID number, person on whom behalf the transaction was conducted, the type of currency. It's really self-explanatory. Like, if you have trouble filling out this form, I would just take a step back and make sure that I figure out how to do it. But here's an example. It's real easy. Second page, anything that needs to go on there, if it's required, but if it's not multiple parties, you don't really need to do anything with that. Now, same thing with the UCC example. We got it like this, where your all caps is the secured party, the filer is your upper and lowercase, the collateral is you claiming your account number, all security interest and proceeds, and all applicable language for perfecting security interest. So everything that you can think of in regards to security interest, proceeds, insurance, all of those things, you're claiming that back for yourself. And again, once this is filed, they have 3 days to dispute it, and if they don't, it holds up. Like I said, I included a link to where you can get the stamp that you will need for the stamp process, and also to the OCC Asset Securitization Manual. I strongly recommend anybody who is looking to get into any of these processes download and read that manual, right? So I hope you guys enjoyed. This has been the full comprehensive guide to discharge and mortgage fraud. I hope everything was clear enough. If I see a lot of the same questions in the comments, I'll make sure to come back and address them. I'm still going to be taking my break. By the time this gets released, I will have dropped the book along with it, and you guys can digest that for a little bit. And I'm going to keep on working and improving. So I just wanted to give y'all something to work with. No drip feed. This is everything that you could possibly want to know. And if you've been with us for the past 2 years, I know a lot of this is going to hit different after this lesson, because I really go into a lot of the stuff that just doesn't get talked about, and how to navigate this space properly. So I hope you guys enjoyed and got what you needed, and I will make sure that I talk to you next time.